morning, ladies and gentlemen of the jury. The state of Florida thanks you all for your time and attention that you have given the past 2 weeks, and including the verdicts. Jonathan Quiles is now a 2-time convicted murderer and a convicted sexual batterer. Each of you know the horrendous facts that occurred in this case back in December of 2018. Each of you know why the defendant killed IS. Each of you know why the defendant killed IS's unborn child. Each of you know how the defendant killed IS and her unborn child. You all know about the ongoing sexual abuse that the defendant did of IS in the late 2017 going through 2018. Each of you did justice when you convicted the defendant beyond a reasonable doubt of premeditated murder of IS and the premeditated murder of IS's unborn child. Phase 2, though, ladies and gentlemen, is about fully holding the defendant accountable for each of his actions that led to why we are here today. State will rely on the evidence that you all heard during those 6 days in Phase 1. We will now commence Phase 2, which will be the weighing process. And Mr. Skinner discussed this during, if you can recall 2 weeks ago, during jury selection, going into that second and third day. Now, the first thing that will be asked of each of you is if the state has proven beyond a reasonable doubt the alleged aggravating factor. Now, we have alleged 5 different ones for each murder. However, there are 4 in common that will be applicable to the premeditated murder of IS and her unborn child. And then there is a different one that will be applicable to IS, and a different one that will be applicable to only the unborn child of IS. Now, if each of you find unanimously, beyond a reasonable doubt, that at least one of these aggravated factors we have proven, then you can move on to the second step. And that second step is where you weigh and whether the aggravating factor is proven is sufficient. If you find that the aggravated factor is then sufficient, you then will move on to the third and final step, which is whether the aggravating factor outweighs any mitigating circumstance provided by the defense, and that has been proven by the greater weight of the evidence. Now, again, as the fact finder, as the juror, you can determine if that weight is great, medium, slight, or holds no weight. That is, again, your right, your choice as a fact finder, as a juror in this case. Now, an aggravating factor, it increases the gravity of the crime or the harm to the victim beyond the harm inherent in every first-degree murder. And again, you will hear victim impact evidence. However, this is only to demonstrate the victim's uniqueness as an individual and the loss to the community of the victim's death. However, victim impact evidence must not be considered by you when weighing each and every aggravated factor that the state of Florida has alleged. The aggravating factors, I'm just going to cite a couple of points and then move on, ladies and gentlemen. The first one is that Jonathan Quiles was previously convicted of a felony involving the use or threat of violence to another person. And keep in mind, the crime of sexual battery is a use or threat of violence to another person, just like each murder is. So if you all think about it and count 3 of the indictment, Previously, because we have heard that he was convicted of sexual battery. He was convicted of 2 counts of murder. So in thinking about IS, that previous felony, because the defendant is now a convicted 2-time murderer and sexual battery, you can use that sexual battery, or you all could use the murder of the unborn child of IS. 4, when weighing whether or not the murder of IS. Then when thinking about the unborn child of IS, you can weigh that again, count 3, the sexual battery, and also you can then also weigh the murder of IS for count 2. And just thinking again about SS witnessing the incident about a year ago at that 1503 16th Street, the DNA results from March of 2018 regarding the sexual battery, and the IS was staying the night with the defendant during the weekend of July 7th, 2018, and that she was pregnant over 5 months at that time. The long drives, as we had heard evidence from, we submit that you had heard evidence involving the Trout River location and the defendant's van. And again, lastly, the defendant's statements and confession to the wire, which is State's Evidence 66. Been about a year the defendant had stated, or maybe less than a year. And it had been about a month prior to the last time the IS had sex, given the fact, too, that the sexual battery had occurred and had been occurring prior to December 19th and 20th of 2018. The next one for consideration that's alleged aggravating factor by the state of Florida. The first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. Well, again, we have heard that the defendant, even with the thought we submit that it was his child, it didn't even have to be his child for the defendant to have committed murder on the unborn child of IS or of the murder of IS. In fact, in State 66, in the wire, quote, "If she had gave birth to that baby, I'd been sitting right here with y'all." She was killed to avoid sexual battery charges, and the unborn child was killed to avoid sexual battery charges. Next alleged aggravating factor by the state of Florida was that the first-degree murder was especially heinous, especially atrocious, or especially cruel. So I like to point out, it's an or. State of Florida does not have to prove all 3 by a reasonable doubt, but we do have to prove one of those by a reasonable doubt. And Your Honor will go over what those definitions are again later today. And again, in thinking about those terms, what we heard during the evidence in Phase 1, again, the IS was 5 months pregnant between December 19th and 20th, 2018. The defendant stated that after he falsely lured her to his employment at Ace Pickup Parts, that they would run away. He strangled her, but he could not stomach it. Basically as a way to kill her, so eventually shot her in the chest and the heart. And again, we had heard this from the confession of witness testimony of Joseph Quiles, the brother. Next, the alleged aggravating factor by the state of Florida that we intend to prove beyond a reasonable doubt. The first-degree murder was committed in a cold, calculated, now this is an and, so we have to prove all 3, premeditated manner, without any pretense of moral or legal justification. Again, in thinking about count 1 and 2, thinking about cold, we submit and recall the evidence to you all regarding what Naomi Mobley stated. After IS went missing, he slept like a baby. Also, too, in hearing from Joseph Quiles and what he had stated during his messaging with the defendant back in December of 2018, he talked about the defendant's selfishness as well. Calculated that the defendant planned the murder of IS and her unborn child for months, as we heard from Joseph Quiles during the evidence of Phase 1. Again, about the lure to his work false pretenses, turning off the phone location of the defendant, IS turning off her phone location data, having IS in a remote area of Ace Pickup Park, not having video surveillance located at that place at Ace Pickup Park, the defendant having access to vehicles, a firearm, a forklift, the knowledge of the container and how it would go weekly, getting duct tape, having bags, and then afterwards going to the gun range. The defendant knew in August, as we heard again through evidence through phase 1, that IS was pregnant based upon those Snapchat messages in state's evidence 63 and 64 as early as August of 2018. IS did not want an abortion. We also heard from the evidence during the case that her family members did not want her to have an abortion. Ms. Mobley had stated she found out on December 3rd, 2018. Ms. Naomi Mobley stated that the rest of the family found out on December 6, 2018 during her testimony. And we all know that the pregnancy was confirmed by Dr. Achu on December 13, 2018. The pressure was on the defendant. We also heard from Naomi Mobley regarding his actions, his nervousness, fidgety, something was bothering him, and that he knew the consequences, as stated in The Wire as well, sitting right here with y'all, again, as she had given birth to that child. So we submit the evidence will show that we have proven cold, calculated, and premeditated. The unborn child of IS was a person less than 12 years of age. This is only applicable and alleged to count 2 involving the unborn child of IS. You've heard testimony again that she was 5 months pregnant on 12/13/18 by Dr. Achu. You have seen a picture of IS, which was states 23, where she was pregnant. And you all have also seen state's evidence 24, which is a picture of the sonogram that Dr. Achu performed. That in fact, we feel comfortable that you all will find beyond a reasonable doubt that we have proven this aggravating factor that IS's unborn child was less than 12 years of age on December 19th through 20th, 2018. Lastly, IS and her unborn child of IS was particularly vulnerable because Jonathan Quiles stood in a familial or custodial authority over IS or IS's unborn child of IS. So first, in just thinking about IS, I would submit and bring your attention to count 3 of the indictment during phase 1. One of the elements that the state of Florida had to prove beyond a reasonable doubt was in fact that Jonathan Quiles was in a familial or custodial authority over IS. You all have already found that to be beyond a reasonable doubt. You all have already heard testimony by multiple state witnesses that the defendant was in fact her uncle. IS was over the home. He would teach her how to drive, teach her how to swim, and that Naomi Quiles, the aunt, would not be there, and Miss Kim Mobley would be at work. Now, in regards to the unborn child of IS, I would submit and bring your attention to the testimony provided in the Snapchat messages and then combined with the testimony of Naomi Mobley. When the fact is, well, again, and coupled with the information that we already know, that the defendant discussed about eating and making sure that she got enough food for the baby, as we had read in those Snapchat messages, as Ms. Mobley had indicated the defendant was doing the same thing for IS as the defendant was doing for Naomi Mobley because she was also pregnant at the same time. So ladies and gentlemen, at the conclusion of phase 2, the state will have proven beyond a reasonable doubt each aggravating factor that we have alleged. We will ask you all to then find that the weight, that they are, again, substantial, and that the weight of the mitigating circumstances that the defense will provide will not outweigh each aggravating factor beyond a reasonable doubt, and will ask you all to render a vote of death. Thank you all for your time and attention.
Yes, sir. There's a microphone for you if you need one as well.
Thank you, Your Honor. Good morning, ladies and gentlemen. Again, we stand before you today, and we are asking you to listen to the facts of this. And we've heard your verdict, and we are asking you to weigh the life of Jonathan Quiles. In doing this, we want you to keep in mind that Jonathan Quiles, although you have found him guilty of this act, does have certain redeeming factors. In doing this, we intend to show and bring forward several of his family members, as well as a psychologist, Dr. Jennifer Rohr. You will hear from his family that Jonathan Quiles was raised by his mother almost exclusively, as his father was not in his life. You will also, we believe the testimony you're going to hear today is that until you found him guilty, he had no prior criminal, any other criminal offenses. Jonathan Quiles was 33 at the time of this incident, of which you found him guilty of. Prior to that, he did use drugs and alcohol, mainly marijuana, but when he was a younger child, of which he was engaged in another sexual relationship at a young age, and as such, he quit school at a young age at 15. Since that time, he had 5 children. Up until his arrest, he was raising those children, taking care of all of them, and worked very hard. You're going to hear from both his aunts, his uncles, and his family members as to the type of person Jonathan Quiles is and will continue to be. Now, the state has brought up the aggravators. Again, ladies and gentlemen, you must find him or find those aggravators unanimously. In going through our mitigators that we intend to present, you only need to find a mitigator will outweigh their aggravator in order to find for life in prison. And each one of you can hold that individually. This is not a collective group. You can find your mitigators outweigh their aggravators, and in doing so, you can stand by and hold your abiding belief that death is not the only option. In doing so, the mitigators, again, more of which you will hear through the course of the day, we believe you're going to hear that since his arrest, that Jonathan Quiles has become a trustee at the jail, which is unheard of for somebody who has been accused of a crime of this nature. Not only is he a trustee, he has taken up religion. He reads the Bible to other inmates. He does and has provided to the elderly and the infirmed in the jail and takes care of them. And we believe that the testimony you're going to hear from Dr. Rohr is that although you have found him guilty of this, he can flourish in a controlled setting and provide to those others as such. That, in and of itself, we believe, as you hear these mitigating factors, can and should outweigh the death penalty. Life is always an option. He can be a productive member in a controlled setting and in this facility and provide to others who need assistance. Jonathan Quiles although he is in jail, has no cognitive or neuropsychological deficits. You've heard from his brother who testified here today through the course of the trial. You will hear from him again today as to why you should consider sparing his life and giving him life. The same person who testified in the guilt phase will testify again here in the penalty phase. Again, you will hear that Jonathan Quiles does have a loving relationship with his 5 children. And again, he's a dedicated and hard worker, and that since his arrest, he has no disciplinary reports. He has not gone out and sought more problems, more trouble. He is not fighting in the jail or creating or committing new crimes. That is, again, significant in and of itself. For somebody who's alleged to have committed a crime of murder and sexual battery, he is not going out seeking out new crimes or committing new crimes. At the end of the day, again, ladies and gentlemen, you are the trier of fact. Listen to the aggravators, listen to the mitigators, and keep in mind, one mitigator alone can outweigh their aggravators in your contemplation of sparing Jonathan Quiles' life. And at the conclusion of our testimony, we hope and believe that you come back with that of life in prison. Thank you.